today was day 19 in Karen Read's retrial, and it was devoted mostly to the continued cross-examination of Shannon Burgess. Now, this started yesterday with Shannon Burgess on the stand, and during the direct examination, he laid out why, after looking at the different modules in the Lexus and comparing them with the data that he found on John O'Keefe's phone, that he was able to put certain timestamps onto certain events that happened with Karen Read's Lexus that night. For example, the three-point turn, as well as the backing up maneuver. So that's mostly what he was devoted his testimony to yesterday. Now, during cross-examination, however, some very interesting things came out. For example, and perhaps most notably, is the fact that if you looked at his LinkedIn profile under education, it listed that he does have a bachelor's degree. And in fact, if you look at the Aperture website, it also listed his CV there, and there's a hyperlink there, and you can see his CV there, which also listed him as having a bachelor's. So that actually is incorrect. He does not have a bachelor's. He has an associate's degree, but he has been in the process of pursuing a bachelor's degree, you see, and he's been pursuing that for the past 17 years. So that came out yesterday in cross-examination, and therefore today was continued cross-examination of Shannon Burgess. So let's start off with Robert Alessi's first point that he wanted to make on cross-examination today.
Is this a true and accurate representation of your analysis of Miss Read's Lexus vehicle traveling to 34 Fairview Road and the O'Keefe residence?
Yes.
According to your timeline, Miss Read's vehicle powered on at 12:36 a.m. on January 30th, correct?
Correct.
Now,
Now you can see that from the bottom part of this graph. You see it starts January 29th and it continues to January 30th. So he has this event happening at 12:36 a.m. to 12:08 a.m. And that is on January 30th. So all the events that happened that he is recording and reporting on and presenting this PowerPoint on, he is saying that the date is January 30th. So this is how Robert Alessi continued the cross-examination, showing that every single one of his slides show this time, and it also shows that this happened on January 30th, 2022. Well, when did it actually happen? Anyone who knows this case knows that this actually happened January 29th, 2022. So this is how Robert Alessi set this up, going through all the different slides here, until eventually he led into this point.
according to the Lexus.
Yes.
In point of fact, Mr. Burgess, none of the 5 timelines that we just reviewed from your presentation are accurate at all, and certainly not down to the second. Am I right or am I wrong?
You are wrong.
Are you aware, and if we could go back to the first slide, which is slide 32, and we'll look at each of them quickly.
Sure.
Are you aware that all of the relevant events in the timeline you described in your presentation in these slides actually occurred on January 29th, 2022, not January 30th, 2022? Do you know that?
So that was the point that he made first, that you see that, again, you're making some mistakes in your report by putting the wrong date there. So you may have this down to the minutes and seconds, but you actually made a pretty bad mistake listing the wrong date of January 30th instead of January 29th. Then he moved on to the fact that why did he decide to amend his report on May 8th? Now, remember, he wrote a report in January of 2025, but then all of a sudden, this is what came out yesterday as well, came out that he actually amended his report on May 8th, and the defense got a hold of that on May 11th, and he spoke to Hank Brennan about it on May 7th. So he changed his report. So why did he amend his report on May 8th? So Robert Alessi brought up the fact that there were certain things that he reviewed before deciding to amend his report. Well, what did he review before coming to the decision to amend his report?
So let me just ask you through a question.
Sure.
So it is correct that before you issued your May 8th, 2025 report, that you had reviewed that slide of your colleague, Dr. Welcher, on 1162.2 that establishes the text stream event as 12:31:38 to 12:31:43, correct?
Correct.
You reviewed it before your May 8th report.
Yes.
You
Yes.
also reviewed before your May 8th report the slide presentation of Mr. DeSogra, correct?
Yes, I did.
And Mr. DeSogra is the defense's expert witness.
And before you issued your May 8th, 2025 report, you also had reviewed the January 2025 report of Mr. Whiffen, correct?
Correct.
Each one of and all of those three established that the 11/62/2 text stream event occurred before the last user activity on Mr. O'Keefe's phone, correct?
So this is a very important part of this case. When was the last time that John O'Keefe had any sort of interaction with his phone? So he locked his phone at a certain time and down to the seconds. And all these three people, Welcher, Whiffen, and DeSogra, in their analysis, their analysis shows that the event, this text stream event, which the Commonwealth is going to refer to as a collision, most likely in closing argument, that event, that backing up maneuver of her car, occurred before the last interaction that John O'Keefe had with his phone, which would suggest that he was not hit by the car whenever that event happened. But they're calling this text stream event 11/62/2. So these three people, Welcher, Whiffen, and DeSogra, all have in their report before 12:32 a.m. And then he decides to amend his report to show how, no, really it all does make sense that the variance between John O'Keefe's phone and how you calculate the times, it all actually makes sense that this event, this collision, this what they're calling a text stream trigger or event, could have happened after John O'Keefe's last interaction with his phone.
I'm going to allow it if that's what, let's see what the answer is.
Using either unadjusted timestamps or inaccurately adjusted timestamps. Yes.
Let me ask my question again, and if it's not clear, please let me know.
Sure.
After reviewing what we've discussed, prepared by Dr. Welcher, Mr. DeSogra, and Ian Whiffen, each and all of which established that the 11/62/2 text stream event occurred before the last user activity on Mr. O'Keefe's phone, you then decided to issue a new report that would become dated May 8th, 2025. Is that statement I just made correct?
Yes, that is correct.
Now let's
Okay, so there you go. So that's what he wanted to bring out with cross-examination, that you were just deciding to amend your report and giving it to us in the middle of trial because you realized that according to the report, it's not going to work out with all these reports, Welcher, Whiffen, and DeSogra. It's not going to work out with the Commonwealth's theory. That's why you amended the report, and that's why you had to explain why it's possible still that the variance in John O'Keefe's phone was actually longer than what these people initially thought, and therefore it all still makes sense within the Commonwealth's theory. Well, then remember that yesterday, this is kind of picking up on what we said yesterday. Yesterday, there was a question about whether he considers this an amendment to his report, a supplement to his report, or is he changing the report? So listen how Alessi brings this out again today.
position is you clarified it.
Correct.
But isn't it correct that in your January 30, 2025 report, you did not address at all whether the 11/62/2 text stream event occurred before or after the last user event on Mr. O'Keefe's phone, correct?
Correct.
So he's saying you did not address this at all in your January report. You did address it in your May report, which you just handed up to us in the middle of trial. And then listen to the next question.
But you did that in your May 8th report, correct?
Correct.
You don't call that a change, sir?
No, sir, I do not.
You call that a clarification.
I do.
So he was saying that's obviously a change. You're changing your report. You're adding something to your report. And then he's saying, well, no, I would just call that a clarification. Okay, but he made his point and then he moved on. So continuing on with his cross-examination, he spoke to him about the 3 seconds. There's a 3 seconds increase from John O'Keefe's phone running through the analysis. Again, there's a 3 seconds, which is not accounted for in his January report. But you do find, in the January report, he does talk about it, but he does not talk about it in the May 8th, 2025 report. So here again, you're seeing that you're leaving out certain information from your report. Now, he tried to explain that really, it's not really that he left it out. He just accounted for it in a different calculation. But he said that analysis that you did in your January report, which you specifically spoke about this 3-second offset, you didn't mention at all. You didn't say, oh, I'm going to explain this 3-second offset that I explained in my January report. I'm going to clarify it and put it into this other calculation that I'm doing in the May report. You didn't say that. So even if that's what your position is going to be, Mr. Burgess, even if that's what your position is going to be, that, you know, you really accounted for it in a different calculation in your May report, but you didn't explain anything that you're doing about that in your report. So if you're not going to address it, number one, either address it or at least explain to us why you're not addressing it in your report, at least. And that was also noticeably absent from his report. Then he continued with the fact that he used the word collision in his report. Now, remember, yesterday he was talking about this idea of confirmation bias, that even in science, there can be some sort of confirmation bias, that you have this working theory that you're trying to prove. And even in science, you can kind of do that by trying to confirm what this theory is, instead of going into blind and just trying to put the pieces together like we heard Arca did. So here he's trying to show that you had this confirmation bias and you're trying to prove the Commonwealth's case with your science. And that's why you use the word collision. Why would you use the word collision in your report? So he explained, Shannon Burgess, he explained, well, that he got that idea from the crash reports that he reviewed from the Massachusetts State Police. So now he is getting some information from the Massachusetts State Police, from their crash reports, and now he has that information, and that's why he's referring to it as a collision. So then what Robert Alessi had to show and establish is that just because it is registered as a text stream event doesn't mean that it's automatically a collision, right? Which is why some of the other experts in this case specifically refer to it as a text stream event or text stream trigger, as opposed to collision, because there's a lot of different things that can cause a text stream event. In fact, he brought out that in the 8-month period that Karen Read owned this car, there were 30 text stream data events or triggers. And he's not suggesting that there's 30 collisions with Karen Read's car. And he acknowledged that. He said, yes, that's true. So really, the more correct, the more accurate way to refer to this event is, like all the other experts, that it's a text stream event or a text stream trigger. Don't call it a collision. When you call it a collision, it looks like there's some sort of confirmation bias. So that's what he brought out with that. And then he got back into his misunderstanding of bits and bytes, which again, looks pretty bad to the jury. If this is an expert in his field in digital forensics, that he would mix up a bit and a byte. So he got into that, and he tried to show him that Maggie Gaffney, who did the first chip off in this case, that this has nothing to do with, she didn't do anything wrong. And he tried to show that you're trying to put some blame on Gaffney, on Miss Maggie Gaffney, and she did nothing wrong. This is your misunderstanding, your mistake of a bit and a byte. Don't try to blame other people for it. So that's essentially how he concluded his cross-examination. So then on redirect was interesting, because one of the things that Hank Brennan wanted to show on this redirect is that, number one, he didn't violate the sequestration order, which is what he first spoke about. And also that he didn't discuss with Hank Brennan anything about his testimony, and that Hank Brennan didn't suggest that he do anything with his testimony, and that he should just say the truth and what his testing showed. And so he tried to show very clearly that there was no bias or prejudice, that he was feeling any sort of pressure from the Commonwealth or the prosecutor to conclude in any which way. And then he spoke about the CV and the LinkedIn situation. So now let's see how he tries to rehabilitate Shannon Burgess by discussing why it is on the LinkedIn account it showed his education as something that really he did not earn, showed that he had a bachelor's when really he did not. So listen to how Hank Brennan tries to rehabilitate him.
Do you have any information or knowledge about this trial as it actually occurred until the point when you testified?
No, I do not.
You were asked some questions about your CV. A CV is a resume?
Yes, it is.
Okay. And you were asked about a LinkedIn account.
Yes, I was.
Is your LinkedIn account different than your CV?
Yes, it is.
And in
Now that's true, right? A LinkedIn account is different than a CV, although you're supposed to put the same information in your LinkedIn than your CV. But it's in terms of formality, you're not going to submit your LinkedIn profile when you're applying for a job. You're going to create a CV. So, okay, so that point he's pointing out.
this case, when did you learn that your LinkedIn account was wrong or had not been updated? When was the first time you learned that?
That was yesterday.
Okay, so the first time he learned that his LinkedIn account was not updated, as he called it, was yesterday. But again, the question is, you were the one who set up that LinkedIn account. You put that information in at some point. And when you put that information in, you did not have a bachelor's. And you put in there that you did have a bachelor's, and you didn't put any sort of qualifier that you are pursuing the bachelor's or expected graduation date. You didn't put any of that in. You just put in you have a bachelor's. So even though Hank Brennan's trying to rehabilitate him by saying, well, you didn't find out about this till yesterday, that's maybe true. But when you initially set this up, it shows that you were not being honest, right? But let's continue.
When you started your LinkedIn account, do you remember when it was you set it up?
I do not. It would have been maybe 10 years ago or more.
Do you routinely update your LinkedIn account?
No, I do not.
When you set up your LinkedIn account, the section where it asks for education, whether graduated or ongoing, do you remember filling out that section?
I don't particularly remember filling it out, but obviously I did at some point.
When you
And that's exactly the point. He was the one who filled it out on the education portion, and he put in that he has a bachelor's when he doesn't.
were asked about Aperture's website, how many experts are associated with Aperture?
I could give you a rough number between 80 and 100,
How many offices?
15 or so.
Are you involved in the website design or content?
No, I'm not.
Do you know if Aperture gets the information from their website directly from LinkedIn?
I don't know where they get all of their information from.
Did you ever weigh in or develop your information that was on Aperture's website?
No, not on the website.
You do provide CVs before you come to court, don't you?
Yes, I do.
Now that, again, let's just take that for a second. Let's take that suggestion now the jury's hearing from him, that he's not involved at all with the website, right? The website are some website guys. They're the IT department and they're working on the website and they're updating the website and all that stuff, right? So there's 100 experts there and you don't know where they're getting the information from, right? It's, again, I think it goes against common sense. When you work for a firm, you work for any company, it doesn't matter how big the company is, they're going to make sure that they have the accurate information from you. They're not going to rely on your LinkedIn account. You just applied for the job. You have your CV there. Usually the first few days there, you're setting everything up with them. You're taking pictures. You're developing your profile. You're changing your signature line, whatever you're doing the first few days to get acclimated to the new job. It doesn't matter how big the office is. There's always going to be some people guiding you and you're interacting with these people. And especially when it comes to something like education, they're going to run it by you. And you're going to have some input on what education you're telling them you have. And then, of course, yeah, they're going to actually do the work, the back end work or the software work, and then put in your information into the website. But it doesn't matter how big the firm is, how many experts work at this firm, how many employees there are, how many offices they have. It's those first few days where you're telling them information and they're updating all of their website with your information. It actually may take even more time. But of course, I mean, I think it's common sense that you are going to be ultimately the one that's sharing what information to put on that website. They're asking about the biography. They're not borrowing it from somewhere else. They most likely will run everything by you, for certainly when it comes to these type of details. So I'm not sure if that's going to work on the jury, but that's what he's suggesting here.
In this case, you were asked by the defense, when you provide your CV, do you understand that it's going to be reviewed by whoever requests it, the Commonwealth or the defense?
Yes, I do.
And that it will be shared with both sides in the court?
Yes.
In fact, the first time you provided a CV in this case, was it October 11, 2014?
Objection, Your Honor.
So the leading nature sustained.
Do you remember the first time you provided a CV in this case?
It would have been around October.
What year?
And just to make a point here, technically it's a leading question, but you're on redirect. So if everything has already been established already, indirect examination and cross-examination, so even on redirect, you should be able to say that what's already been brought out in testimony. So, I mean, he could have said, okay, we already established that you handed in your CV, your first CV in October 2024, but that's just, nitpicking over here.
2024, sorry.
And when you provided that, was it as an exhibit to something?
Yes, if I recall, it was as an exhibit to the initial protocol that I sent out.
And when you submitted that CV, did you appreciate whether or not it would be part of a court filing in public?
Yes, I did.
If I could have exhibit 183, please.
So he's just trying to show that when you submitted this CV into this case, it was accurate, right? Because you did write there that you're pursuing your bachelor's degree. He didn't say you've been pursuing it for the past 17 years, but you did say that you're pursuing it. So he's just trying to show that the CV that you actually submitted in this case is accurate. And because it's a court proceeding, you're going to be much more careful about it. And so
No,
that's what
disagree.
he's just bringing out right here.
Yes, I was.
Did you do that?
I did.
And can we have exhibit 184?
So you're showing the next CV that he...
Defense?
Yes, I did.
Did you represent to the defense that your education included earning a bachelor degree?
No, I did not.
You've testified in, you can take that down, please. You've testified in many other cases
I have. Yes.
in courts around the country.
Yes, I have.
And when you testified in other courts around the country, do you know whether there are transcripts of your actual testimony?
Yes, I believe there are.
Have you ever represented in any court that you achieved your bachelor's degree?
No, I have not.
Have you ever inflated your qualifications in a court?
No, I have not.
Okay, so he's saying, look, you've never, when you actually testify or when you actually are involved in a legal proceeding or a court proceeding, that you're not submitting these CVs or resumes that are incorrect, right? So then what happened here is that the defense, Robert Lussey, when he came to recross, he showed him that there was actually a federal case, which was he was involved with, Mr. Shannon Burgess, that was date stamped or time stamped August 7th, 2023. And in that case, Aperture was hired and he was involved in the case, and they attached that CV that we find on the Aperture website, which lists that he has a bachelor's degree, and it was submitted in that case. So he claimed, and when he was asked about this on cross-examination, he said, well, he was the one that submitted it. He wasn't the one that actually filed it. Somebody else from the company of Aperture that filed it. It wasn't him personally, so he didn't know about it. But he did bring out, Robert Lussey did bring out the fact that he was aware that they were going to submit a CV on his behalf in that case. And it would have been prudent of him, definitely, that if you know that a CV is going to be submitted on your behalf, even if you're not the one who's sending the email, but you know that this is going to go on in court and your qualifications could be called under scrutiny. So then you definitely, it's prudent of you to look over your CV before you actually let it get submitted. So that was brought out on recross as well. So that's in terms of that specific issue with the CV. Now, he eventually also again explained that the difference between DeSorga and the what his analysis was the following, just so you should all understand. What he's claiming is that DeSorga, which is the defense's expert. I'm sorry. The defense's expert in this case is DeSorga. A lot of D's there. And DeSorga is going to show in his report that he also did this type of variance calculation. And according to his calculation, the difference between the Lexus and John O'Keefe's cell phone is 16 to 21 seconds. And if you do the calculation using DeSorga's variance of 16 to 21 seconds, you're still going to end up with this text stream event, this backing up maneuver, before John O'Keefe's last interaction with his phone, which is why he's going to be called by the defense to show that even if we take all this text stream data and plug in all the variances to John O'Keefe's phone, you're still going to end up with a time that shows that this event ended before John O'Keefe's last interaction with his phone, which again would mean that he was not hit at that time. So what Burgess is trying to say is that DeSorga's information was inaccurate. The reason is that DeSorga used information that he obtained from the 5:00 a.m. time when Karen Read got back into her vehicle that morning, early that morning when she went to go search for John O'Keefe. That's the data that he was using. And Burgess is saying that I used the information from the three-point turn, which was much closer in time to the backing up maneuver event. And therefore, it's more accurate. And if you'd used that time, use the three-point turn, then you see that it's actually more than 21 seconds and could account for this backing up maneuver to end after John O'Keefe's last interaction with the phone. So again, he brought that out on redirect. So moving on, then Hank Brennan showed some more clips of Karen Read. I'm telling you, these clips are not good for her, and he's using them to his advantage. So let's see what these clips say here. Let me just pull it up. And we have to slow it down a little bit because the clips, you have to be very careful to hear every word.
So we approach from the north, we actually missed the turn, and John says to me, it's Fairview, we just passed it, it's back there, it's on my left. I said, all right, so I pull nose into a driveway and back out onto the street, which I now own was Cedar Crest, and then come from the north onto Fairview.
So the point of that was just to show that here's Karen Read admitting that she did the 3-point turn, which I don't think the defense is going to dispute. So, but that's just in her own words that she's agreeing that she missed Fairview, did a 3-point turn, turned around, and went down Fairview. Okay, so there can be no dispute about whether she actually did that 3-point turn. And then again, that's supposed to, the reason why he played that right after Burgess's testimony is to show that that Burgess's data was going based on this 3-point turn, which actually did happen. Let's move on to the next
play,
clip.
clip 25.
At 12:41, I leave a voicemail to John where you can clearly, and this will probably be played on Monday, you can clearly hear me pull into John's garage. You can hear my car sensors beeping as I come close to the sides of the garage door. And then you hear the car go off, and then you hear the slight ding, ding, ding as I open the door, shut the door. I had high heels on the night. You hear me walk in, go into the stairs up into the kitchen, shut the door, and you hear me walk in the kitchen. It's like a full minute long. That's at 12:41.
So this is Karen Read saying that she got home to John O'Keefe's home at 12:41. Now that should really help the Commonwealth because remember, if this happened at 12:32 and it's about a 6 to 8 minute drive back to One Meadows where she was staying that night, well, then that means that she could not have been there before 12:38 or 12:40. So here she is saying herself that she got home at 12:41. So this should help the Commonwealth's case. However, the problem with this is that Trooper Garino already testified that she connected to John O'Keefe's Wi-Fi at 12:36. So 12:36 she connected to the Wi-Fi, and here she's saying, well, I got home at 12:41. So now this could also, again, this is going on her memory. This is 2024. So she's going on based on her memory, and she's saying 12:41, where you have the actual data from her phone saying that she connected to the Wi-Fi at 12:36. So if you had to ask the jury who you're going to believe, you're going to believe Karen Read, in 2024, trying to remember exactly what time, or you're going to trust the data from the phone from the Commonwealth's own witness who said that she connected at 12:36. Now, there can definitely be a possibility that she connected at 12:36 and she didn't actually get in the house at 12:41. You can definitely make that argument, but still, you're going to have to rectify the data, which shows that she connected to the Wi-Fi at 12:36. And if this accident happened at 12:32, that would make it that she'd have to get back to John O'Keefe's home around in 4 minutes, which is generally a 6 to 8 minute drive from what we're hearing. So, but that's, again, it definitely would help the Commonwealth if they can just use that time of 12:41. All right, let's move on to the final clip.
And finally, clip 24.
I do. I mean, I'll tell you, John and I argued the morning of the 28th, Friday morning. So we think he died right around 12:25, 12:30 on the earlier morning of January 29th.
So he played that saying that, okay, she's acknowledging that she got into an argument with John that morning, and then she thinks that he died around 12:25, 12:30. All right, so that was the clips that they played, and then we heard from Christina Hanley. Christina Hanley is a forensic scientist, and she was trying to put together the glass. Now remember, there's a broken glass, the glass cup that was recovered from the scene, and there's a bunch of broken pieces of glass around the street and also on the bumper. So she was tasked with trying to compare and find any comparisons between the glass cup, and all of these pieces, shards of glass that were left around the car and the bumper. So let's see what she says right here, which is probably the most interesting part of her testimony so far. She's going to be called back tomorrow. Let's just pull this up. and see what she has to say about certain pieces of glass that were discovered on the bumper. We saw those pieces of glass on the bumper already. Let's see what she has to say about whether those pieces of glass on the bumper match. Now, definitely, there were definitely pieces that matched. Let's see about the glass pieces on the bumper.
The bumper. And there were 5 total from the bumper. 2 of them I used for physical match comparison. And there was no physical match comparison between those 2 pieces from the bumper item 3-3 compared to the glass pieces and the cup that were recovered from the road.
So those 2 pieces of glass that she tested to see if there's any comparison with the glass cup, they did not match. So where did those pieces of glass come from? Or can she just say that it's possible they match, but I couldn't definitely say that they do match? Maybe it's still possible, but I can't tell you definitively that they do. So she just started her testimony at the end of the day today, and we're going to continue with her testimony tomorrow. So we will all see you right back here tomorrow for the live stream beginning at 9 a.m. I heard something from Judge Cannoni at the end of the day today that maybe I'll see you later in the morning. So I didn't hear any more reports about that, but assuming they're going to start at 9 a.m. tomorrow. So we will be right here covering the action. Definitely join us for the live stream to see what Christina Hanley has to say, and then we'll see what other witnesses are in store for us tomorrow. So that's going to be it for today. That's the recap. If you haven't yet, please subscribe and like, and we will see you next time.